Hello, my name is Benjamin Hart. I'm an American attorney and the Managing Director of Integrity Legal here in Bangkok, Thailand. In this video, we're going to briefly discuss I-601 waivers and the ground of inadmissibility for overstaying in the United States. Pursuant to the provisions of the Immigration and Nationality Act, one ground of inadmissibility for coming back to the United States is it will be triggered, the ground of inadmissibility will be triggered if an individual has been in the United States previously and if they've overstayed while in the United States previously. Now, with respect to whether or not the actual trigger has occurred, I strongly recommend that you speak to an immigration attorney of some form, because the actual trigger for the overstay can heavily depend on the status that the individual was in at the time they were in the United States. What I'm talking about here is there are certain kinds of tourist visas where, or I'm sorry, not tourist visas, student visas, etc., where a person may be in what's called duration of status because they're doing some sort of post-academic research or work or something, so there was no clear date when that individual would have specifically been in overstay. And the other thing to keep in mind, one needs to ascertain the status that the individual in question was in while in the United States, as that's determinative of whether or not the overstay bar applies. So to be real specific on this, this is just a general overview video. It is not specific advice or specific information regarding a specific situation with regard to overstay in an I-601 waiver. But that being said, this is just here to provide some general overview information about what can occur in the event that someone is found to be inadmissible for overstay. Some things to keep in mind with respect to overstay, and I prefer to kind of redirect from sources when it comes to issues involving overstay. So with respect to how long one is barred from re-entering the United States, it should be noted a 3-year bar to readmission to the United States will be triggered if alien voluntarily departs the United States after being unlawfully present for more than 180 consecutive days but less than 1 year. So if one finds themselves in overstay for more than 180 days but less than 1 calendar year, or 365 days, I guess is probably the more specific and better accurate note for the numbers, the individual in question will need to go ahead, and if they voluntarily depart, they're only going to be barred from re-entry for 3 years. So there's sort of a prong to this where essentially you are you can voluntarily leave, get in compliance, and they're not going to put an incredibly onerous burden on you as far as returning, or not burden on the individual from returning. However, a 10-year bar to readmission to the United States will apply if the alien departs voluntarily or not, or involuntarily, after being unlawfully present for 1 consecutive year or more. So the thing to keep in mind with this, and to be specific with respect to the overstay issue, is the fact that the 1 year, if you overstay for a year or more, you're in the 10-year bar territory. But if you find yourself not at that level yet, one may want to go ahead and get right with the situation, as it were, go ahead and get their situation sorted out, because failure to get it sorted out before the 1 year mark could create a really serious inadmissibility problem. Okay, so setting aside all the notions of inadmissibility, let's go ahead and sort of cut to an alien, let's say specifically here in Thailand, has been found to be inadmissible by a consular officer at the immigrant visa unit, presumably at the immigrant visa unit, although it could be at the non-immigrant visa unit. Let's just say at the consular section at the U.S. Embassy. Let's go ahead and say that that individual has been found to be in overstay and to be inadmissible to the United States. What's the remedy? Well, the remedy is exactly as the title of this video suggests, the I-601 waiver. One needs to go ahead and prove up the requirements of the waiver in order to go ahead and obtain, in order to get the inadmissibility waived, and thereby be allowed to enter the United States. So the first thing to ascertain is one needs to know their situation with respect to the kind of overstay bar they're looking at, and then one needs to go ahead. It's probably a good idea, even before the visa process starts, to go ahead and contact an attorney, and B, if you think it's going to be an issue with respect to overstay, it's probably a good idea to know that at the outset, and an immigration attorney can have certain protocols prepared in advance for dealing with that overstay issue, and essentially basically getting an I-601 on file as quickly as possible, so as to ensure as fast and quick a processing time as one can get. Another thing to keep in mind is the I-601 waiver process is its own adjudication in its own right. It has its own processing time separate and apart from the underlying processing time for, say, a K-1 or an IR-1 or a CR-1 or any visa. I usually specifically like to talk about family visas because that seems to be predominantly what gets processed through the post here in Thailand. That being said, employment visas can be affected by a prior overstay, as can certain types of transfer visas, and even non-immigrant visas can be affected by prior overstay in the United States. And adversely so. If one overstays their visa status by a significant portion of time, one can seriously be impaired from returning to the USA. That being said, it's probably a good idea, again, if you know there's an overstay issue, and in issues involving inadmissibility arising out of overstay, generally one's going to be pretty aware of that prior to even filing the underlying case. Not a bad idea to get on the phone to an immigration attorney such as myself if you're dealing with this out of Thailand, and go ahead and get a plan of action in place before even initial filing, so one knows exactly what one's looking at with respect to the overall processing time and what to expect from the overall process, as needing to deal with an I-601 waiver will substantially change the way in which the overall process will operate.